Rishma, my apologies. I know you have some other commitments. I'm sorry that we went over time, but please.
That is quite okay. I've taken care of those when I saw that it was sort of going over time. I've made contingency plans, so don't worry about it.
Okay.
I will
Good
try
Girl Scout, you're
to.
prepared.
I'm always prepared. We have to be. Attorneys have to be that way. All contingencies. I'm going to try to, I guess it's sharing my screen, right? Where I can select, yes, my presentation. Okay. So thank you, Wesley, for inviting me to speak. I think it's very, very important. The information, I want to just repeat what some of our panelists have said before as well, that is very important for our communities to be able to have access to this information. And so it's actually a great thing. And I hope that you would consider joining with our other Caribbean Chambers of Commerce so that we can have a collective, maybe Caribbean conference moving forward. But I'm just putting it out there if you so choose to. Let's see. My name is Rishma Eckert. Here we go. My name is Rishma Eckert. My law firm is Eckert Law PLLC, and we are a business law firm that's based in Florida in the US. My main areas of practice: company formation, governance, contracts, trademarks, and copyrights. And we do represent a number of international clients with the drafting and negotiation of their goods and service agreements. Now, in the first panel and also on this panel, I've heard a lot of really great information on the very technical aspects of products that are being exported, very technical aspects of maybe logistical ports of entries and so forth. But what's also very important for an exporter is before you even get to the point where you're exporting, you're having a buyer for your product. And you must have some sort of comprehensive contractual relationship with the person or the company that's buying your product. So my focus today would be on those contract law considerations for the buyer of your product as an exporter. So because of the interest of time and 10 minutes, I've decided to focus on 4 major issues or topics within contract law where I find that, it's usually the most litigated parts of the contract, and it's usually what I see as the most contested or disputed parts as well. So those would be doing some pre-contractual due diligence of the companies that you're working with, your transport terms, your payment terms, and very, very important also is your choice of law or your choice of venue. So moving on, we have pre-contractual obligation. I say pre-contractual because this is what I would do if I were representing you in a negotiation. The first thing I do is I do my due diligence, and I would encourage you to do the same for the US companies that you are going to be selling to. So my suggestion is to make sure you check your company's status and history. One of the ways that you can do that is that's absolutely free as long as you have access to the internet, is that you can go to wherever that buyer company is registered, the state in which they're registered in the US, and you can go to their Division of Corporations website and you can check the company. So for example, I'm in Florida, so I go to sunbiz.org. All the records for the companies are usually public record. And I don't necessarily mean like the ownership of the company and all that, just how long has they been in existence? How many amendments have they made? Have they been removing people left, right, and center? What is the stability of those company records? Those are the types of things that I would look at in terms of due diligence. Checking a company's reputation. Again, you have access to the internet. You can go and see on any state clerk of court site whether or not that company has been sued for breach of contracts. Again, it's all public record. You can check for lawsuits. You can go on the Better Business Bureau website and see if there's any complaints about that company. And my favorite thing is you can Google them, because more than likely if there's been a dispute or something like that, someone has written about it. So again, check the company reputation. Another thing that you can do if someone, a company in the US gives you a purchase order, it's important too, especially considering the amount that they're going to be asking for, is to try to get proof of funds from them. And this is easily done. A lot of banks will issue proof of fund letters. You can ask for bank statements just to verify the company that you're working with. And lastly, if you so choose, you can ask for professional references as well. Talk to the company, ask them who their former or current clients are, who their colleagues are, who their vendors are that they're working with. And again, these are all pre-contractual, I would call them obligations that you would have as a business owner to make sure that, you know, you're not getting the bad end of the stick in terms of the transaction. Secondly, I would encourage exporters to look at the transport terms within the contract. Now, I do realize that a lot of times, and this happens a lot within my firm as well, you will have a purchase order that you get from the person who's buying within the US. And that purchase order may or may not have specific terms on them. I always encourage exporters to have their own contract or have their own terms that they're going to suggest to be added to that purchase order or to have the buyer sign. So one of those things that you would want to include is that the transport terms. And as you guys may or may not know, the use of Incoterms is very, very, very important with those transport terms. So for those of you who do not know, the Incoterms are the International Chamber of Commerce recognized terms for how you go about doing your buying and your selling of goods. They usually define the responsibility and the risk of loss between the buyer and the seller. And this becomes very important if it becomes a litigated issue. So for example, you'll have different Incoterms for your land transport, your sea transport, and the two most commonly used ones that I've seen for sea transport is FOB, which is free on board, and cost insurance freight, which is CIF. So what does all of this mean? What it means is that if you get into a litigated issue and your product is lost at sea, how do you go about taking responsibility for that? Who bears the risk of cost? And that is one of the most important things that you will deal with in terms of exporting to the US. The other thing in terms of the transport terms that you want to make sure that you have is to have some sort of streamlined shipment information. Now, a lot of my companies that I represent, they have their freight forwarding companies that will do the import documentation, and all that is pretty much standardized, and sometimes they'll coordinate logistics. So it's important for you as an exporter to know not only the technical information about the products themselves, but also what is my streamline for when it gets to the US, how is it going to be handled, how does it get to the end buyer, and those types of things. Moving on, looking at the payment terms. Again, very, very important to have within a contractual relationship with a buyer, what type of payment terms we're looking at. I always suggest that you clearly define the when, how, and what happens if not. What I mean by that is within that purchase order that you have, within that contract that you were given to review or that you want to issue, do you have an example of whether or not your payment is due upon receipt, whether it's net 15 or net 30? How do you go ahead and make that payment? Is it going to be by wire transfer? Is it going to be deposited in a specific bank account? If so, make sure you have that bank account information there. And all of this, again, is to make sure that you're streamlining your payments. There's no delays. There's no cause for going back and forth and trying to figure things out. Another thing that I always suggest for those contractual relationships is having some sort of incentive for payment. So for example, if you pass that deadline of the net 15 or the net 30, do you have late fees that are within your contract? Do you have interest fees that are being paid? So those are the types of things that I would suggest that you have within your contract. Also, breaches and consequences. Are you clearly defining within your contract what is considered a breach and how you go about dealing with that breach? I have, for example, do you have a grace period for the payment? So for example, if you do not pay within the 15 or 30 days or due upon receipt, are you giving them a cure period? Are you giving them time to, a grace period, sorry, a time to pay that's beyond when it's due? What happens in the contract if you have to cure some sort of defect? For example, you ship a product, it ends up being damaged. The contract may give you time to go ahead and cure that damage to still be able to keep your payment, and also logistical ways to keep that. So for example, if there's a cure period and you as an exporter now has to ship goods to your buyer in the US, who pays for that shipment? Who pays for things going back and forth? Because those might get very expensive. So it's very important that you have that within your contract. Consequences as well. If there is a breach, what happens? Are you going to go straight to dispute resolution? And that brings us to our choice of law and our court. Very, very important to talk about the choice of law. And I'm going to spend just a few minutes talking about this because I see this as one of the major mistakes that I see in purchase orders or contracts coming from other countries to the US. Now, when I say choice of law and venue, what I'm talking about is if you have to take someone to court, if there is a dispute, where is that dispute going to be handled and under what law? Very important. If you have companies in two different areas, Guyana and the US, and there's a dispute, where is that going to be litigated? Now, the buyers and sellers, you have the option. You are in control of your transaction. You definitely have the option of choosing whether you want to be governed by the CISG, which is the Convention on the International Sale of Goods. It's an international convention, which Guyana is a signatory and the US is a signatory as well. So you can choose contractually if you would like to use the rules of CISG to govern that dispute, or if you would like to choose another legal jurisdiction, meaning is that breach of contract now going to be heard in Guyana or is it going to be heard in the US? Now, the factors that I use usually to consider writing this into a contract is the time for the case to be heard in that country, the enforceability, and the location of the asset. What I mean by that is, if you're in a country where your breach of contract case is going to take 20 years to get to court, whereas in the US, it's going to take, I don't know, a couple months to be able to, for you to be able to have some sort of time in front of the judge, and then you would maybe want to consider having your jurisdiction within the US. Another thing is, if you say, well, I'm a Guyanese company, I want to just be, you know, I want to use my system. I know my system, I'm going to be able to use my system. And you take that to court, you get a judgment from a court in Guyana. That's not the end of it. For you now to be able to get satisfaction for that judgment in the US from a US company, you have to go through a process of enforcing that foreign judgment, because at this point it would be a foreign judgment. You would have to enforce that foreign judgment in the US to be able to even get satisfaction for your judgment. So what that means is that you have to go through now another process, sometimes even more expensive than the initial process, to be able to enforce what you've done in your foreign country. So my suggestion many times, and there are some exceptions, but my suggestion many times is to follow where the assets are. If the company that you're shipping your goods to is in Florida and they have not paid you, where do you want to sue them? Probably where their assets are in Florida, because if you go ahead and get a judgment there, it's going to be it would be much easier to be able to get a satisfaction of your judgment in the US as opposed to in your foreign country. So what does that lead to? You may say, well, I don't want to go through the problem of going to Florida, hiring an attorney there, taking them to court and all that. If you do win, you can write into your contract. Again, everything is very transactional, contract governed. You can write into your contract what's called a prevailing party clause, meaning that the non-prevailing party, the person who loses the lawsuit, would be liable to pay your legal expenses if you win. You can write that into a contract. So I don't want you to think about the distance and hiring of an attorney in the US to be something that may be a deterrent. And the reason I'm spending so much time talking about choice of law is because this is the single most, this is the biggest issue that I've seen on most contracts that have come to me already written and signed, is that now you're stuck in a situation where you're bringing a lawsuit in your home country, but now all you have is a piece of paper as a judgment, and there's no way for you to actually get to the US company. So I say all these things, and again, this is a very quick, very, very bare bones analysis of what you need in a contract. Obviously, you're going to need a lot more. But these are the 4 things that I've noticed that are the most litigated issues within an actual contract. So keep those in mind when you're having your contractual relationship with your buyer and your seller. If you have any questions, you can go ahead and call me, email me, follow me on social media. And thank you so much for this opportunity to be able to speak with the Guyanese people and getting back to my roots, because I was born in Guyana, raised in Belize. So for me, it's very full circle and satisfying for me to be able to do this presentation. So thank you very much, Wesley. And I
Thank
will
you
be
very
able
much.
to answer any questions anyone may have. I will be more than happy to answer.